Welcome everyone to this session of the DEMOS21 lecture series on contemporary European democratic theory. It's a hybrid event, so we have a number of people here in the conference room, and then there are a few other colleagues joining online, which is great. It seems to be working out well technically, and I hope that will continue that way for the remainder of this session. So it's a great honor and pleasure to have with us here this late afternoon Eva Erman from the University of Stockholm, where she has been professor in the Department of Political Science since 2015. She is founding editor and editor-in-chief of the journal Ethics and Global Politics. Similar to the topics covered by that journal, questions of global governance and human rights, global justice, global democracy, she also works on these issues of theories of transnational and global democracy, human rights, and more recently she has been working a lot on methodological issues, question of the relation between ideal and non-ideal theory, the relevance of practices in political theory and philosophy. And her latest book also has this focus on practices. It's called The Practical Turn in Political Theory, came out in 2018 with Edinburgh University Press. She's also the author of Human Rights and Democracy, Discourse Theory and Global Rights, which came out 2005 with Routledge. She edited several volumes on questions of international, transnational democracy, such as, for example, Political Equality and Transnational Democracy with Palgrave 2013, or Territories of Citizenship, also with Palgrave 2012. She has a very long list of journal publications in journals such as Ethical Theory and Moral Practice, British Journal of Political Science, a Critical Review of International Social and Political Philosophy, Philosophical Papers, and many others. And in these journal publications, she covers these issues that I've just referred to and which represent her research areas. One of her areas related to the broader debate about global democracy and democratic theory is her interest in the democratic boundary problem. And she's an expert in that particular domain, and the paper she's going to present, and which has been shared among many of you that are participating today, is the paper called The Boundary Problem of Democracy, a function sensitive view. And if I understand it correctly, the paper is already accepted for publication in Contemporary Political Theory. That said, we are nevertheless eager to engage with your argumentation and find some of the weak spots and see what the contribution is to the final and eventual solution of the democratic boundary problem. There's supposedly insolvable problem eventually having been solved by Eva Erman. So very much looking forward to the discussion. Thanks so much for being here with us today. Eva will start with a presentation of 20 minutes or so, and then that will be followed by a discussion. I hope you're able to share your screen. If not, I will enable you to do that.
Yeah, I have. I can share my screen. Yes. Thank you for the introduction. They recently opened up for full audience at the football games here in Sweden. So I lost my voice 2 days ago. There was this very important derby between two of the main Stockholm teams. 35,000 people screaming, and I was one of them. So that's why I sound a bit, tired in my voice, but I hope you can hear me anyway. Okay, so let me now share the screen here. Can you see that?
Yes.
Okay. Yes. So the boundary problem, I mean, as an editor, I hate when I get submissions about the boundary problem because it's like impossible to get reviewers to say yes. I maybe it's getting better now, but for a few years then people were so exhausted by the all affected principle and everything. So it seemed like the debate didn't really move forward. So, but when I told Julian that I wanted to present this paper, it wasn't accepted because it's very boring to present accepted papers, because that's not a motivating force for the audience. Not have you want to make a difference and you want to show that, you know, you want to revise your. So, but anyway, this is an ongoing project of a more broader idea that I have about function sensitivity in democratic theory. So it's part of that larger idea. So this one is the boundary problem of democracy, a function sensitive view that I'm going to try to present briefly today. Okay, let me move away so I don't see the pictures. So the basic core of the argument: in response to the democratic boundary problem, two principles have been seen as competitors, as well known by many. Some version of the all affected interest principle and some version of the all subjective principle. So this paper claims that these principles are in fact compatible because they're justified vis-a-vis different functions, accommodating different values and drawing on different sources of normativity. And this is what I call the function sensitive view. So more specifically, I argue that the boundary problem draws attention to the decision functions of democracy, and that two values are indispensable when theorizing how to regulate these functions. And that's procedure fairness and political autonomy. While the value of procedure fairness is best promoted through a version of the all affected interest principle, I argue, applied to decision-making generally, it's argued that political autonomy is best promoted through some version of the all subjective principle applied to coercive decision-making specifically. So the last section of the paper, I tried to draw out some practical implications of this function-sensitive view for the case of immigration and border controls, but I don't have time, will not bring that up here today. I don't think we will have time for that. Okay, basic assumptions. Since it's not always clear what the democratic boundary problem consists of, I want to begin by clarifying a few things about how I see this problem and how it's understood in the paper. There's been a tendency in the literature to regard the boundary problem as insoluble, since every candidate criterion for who should be included in the decision-making already presupposes a demos, a people, who have decided on the rules of the democratic procedure that was applied, and so on. Attempting to solve the boundary problem therefore leads to infinite regress. This is a famous argument. So, however, I mean, despite that this purely procedure reading of the boundary problem has been surprisingly influential in the debate, I think it's neither damaging nor very interesting for democratic theory. In democratic theorizing, we typically do not require that, say, a fair procedure is fair only insofar as its rules have been adopted using that very same procedure. So, for example, no utilitarian would ever suggest that what constitutes well-being should be determined by using the utilitarian principles. So along the similar lines, I don't find this kind of view very interesting. The boundary problem, as I see it in democratic theory, is appropriately seen as a normative problem whose solution calls for an analysis of the values and principles underpinning democracy. So the underlying idea here is that the answer to the question of why we find democracy desirable have implications for what is considered a justified solution to the boundary problem. And if this sounds plausible, there will presumably be different plausible solutions depending on how democracy is justified. So the present paper sketches just one such proposal. So apart from that, the argument also relies on some conceptual presumptions. Here, I see democracy as a normative ideal rather than simply a decision method, which means that the principles offered as a solution to the boundary problem are seen as part of such an ideal. And I think this is important to mention because when you engage with philosophers, they often see democracy as a kind of decision method. And if you hang with political theorists coming from a political science background, they've had this more robust ideal in mind. Furthermore, I see democracy as a partial rather than a comprehensive ideal, which means that the principles of the proposed account generate pro tanto rather than all things considered reasons for inclusion in the decision process. So this also means that democracy might be overridden by a some other ideal, say justice. For example, it might be the case that pursuing democracy would involve two extreme moral costs in terms of injustice. Then democracy, when democracy is studied as a partial ideal, focus is directed what I would call more intermediary principles, rather than foundational ones. So, and then some methodological remarks. The argument is ideal theoretical in the sense that it's about rightful inclusion that is investigated on a general first order principle level without being tied to any particular feasibility constraints, apart from the classical provis ought implies can, such as the existence of well-functioning decision bodies and certain territorial and other borders. And I think this methodological stance, to make that clear, is important because particularly in this debate where this has been quite messy, what people have presumed. So this methodological stance has two implications. The first has to do with how we understand the boundary problem. David Miller, among others, proposes that a plausible solution to the boundary problem must address not only the constituency question, that is, who is to be rightfully included in the decision-making, but also what he calls the domain question, which means that within what territorial jurisdiction those decisions will apply. So Miller correctly observes that in both concrete and abstract formulations, such as affected by decisions or participate in the decision-making, typically presuppose a political apparatus already, coupled with a specified territorial jurisdiction. So the question I ask then from my methodological viewpoint is what conclusions we should draw from this. As I see it, the boundary question in democratic theory, or the constituency questions to use Miller's terms, concerns who should take part in the decision-making. I think this is better to keep this question distinct from asking which empirical conditions must be fulfilled in order for such practice to even get off the ground. Above all, I think it's a mistake, what Miller and Baubeck and others do, to think that a certain empirical priority, in this case that certain practices are needed for the principles to get off the ground, that a certain empirical priority entails a justificatory priority, since the justificatory priority does not follow from the former empirical priority. So a second methodological implication is that I've deliberately tried to avoid speaking about citizenship in the analysis of membership. Instead, membership in the demos is understood more abstractly in terms of inclusion in the decision-making. So against the tendency to bring together or equate the question about rightful inclusion with the question about citizenship, I argue that these questions are best kept distinct. And above all, I think this is important because citizenship is a complex legal notion, and principles regulating citizenship presumably would require a legal structure as a condition of applicability. So this again has to do with methodological stance, and I think also quite messy in the literature on the boundary problem. So a lot of tacit methodological assumptions involved. So now decision functions, basic values, and normative principles. So which principles, I ask, should regulate decision functions from the standpoint of democracy, understood that this partial normative ideal? A problem in the literature is that decision-making is often seen as a single property of democracy, which means that differences between law and policy that might be important from the standpoint of democracy are overlooked. In general terms, laws are both more formal and more fundamental than policies, constituting a system of rules that generally coerce persons by mandating, prescribing, permitting certain relationships between people, institutions, and often backed up by force and threat of sanctions. Policies, on the other hand, typically consist of statements setting out certain procedural or substantive goals that should be achieved in the near or remote future. Importantly, though, they comply with laws and are formulated within a legal framework, even if they aim to fundamentally change the existing law or even identify a new law that is needed. So my suggested function-sensitive account attempts to incorporate these, in my view, normatively relevant differences through two principles that regulate decision functions. So very briefly, according to what I call the democratic principle, P1, which reads that all and only those who are de facto systematically and over time subjected to coercive decisions should have an influence in the decision-making about the overarching societal goals and aims shaped by these decisions. Not a very elegant, short principle, but anyway. Having influence here means having a formalized say in the decision process, at least in the form of voting rights. But one can have much more robust ideas, so this is kind of a minimal requirement. Moreover, the systematically and over time requirements make the principle equipped to distinguish not only the resident from tourist, but also the businessman who visits society on a long-term basis from a long-term resident alien, because they're both subjected to coercive decisions, but the businessman is not likely to be systematically so, even if she revisits often and therefore is subjected over time. So that's my version of the all subjective principle. The second principle is the principle of what I call principle of public legitimacy, P2, which states that all those whose fundamental interests are significantly affected by decisions must have them protected and promoted in a public way in the decision process. So to have them protected and promoted at least means, first, to have them taken into consideration through voice, and secondly, having access to deliberative fora that feeds into the decision process, where deliberation is reflected in the outcome. So this is a very Habermasian view of how the kind of informal track feeds into the formal track in a democratic theory. So having deliberating reflected in the outcome does not entail an outcome-based notion, though, of democratic legitimacy. Rather, in line with Habermas, I see deliberative politics, as it is understood here, is wedded to a multifaceted procedural notion, according to which cognitive procedures of various forms of deliberation are institutionally tied to decision procedures that link decisions to these antecedent deliberations. So, going to basic values now, the democratic principle P1 foremost expresses the value of political autonomy by requiring that one is the author of the decisions by which one is systematically and over time coerced through influencing the decision procedure, which determines the overarching societal goals and aims. P2, on the other hand, primarily expresses the value of procedural fairness by requiring that one is an authority in the shaping one's life by having one's fundamental interests publicly protected and promoted in the decision process. So, as I said earlier, democracy here is a partial normative ideal. Therefore, the democratic principle and the principle of public legitimacy are intermediary principles of political morality. So if we were to theorize this account of democracy as part of a more comprehensive ideal, such as a theory of justice, P1 and P2 would have to be grounded in more fundamental moral principles. But I think they're compatible with most liberal, egalitarian, basic principles, actually. So, according to this proposed function-sensitive view, there are two aspects of the problem of who should take part in the decision-making, which cannot be reduced to one another. So because the demos demarcated by the principle of public legitimacy, P2, applicable to the function of decision-making generally, typically law and policy-making, need not, and will in most cases not, be the same as the demos demarcated by the democratic principle, P1, applicable to the function of coercive decision-making, typically lawmaking as we know it today. So this kind of dual approach to the boundary problem, I think, harmonizes well with intuitions about what is wrong with applying the all affected interest principle or the all subjective principle in the case of, for example, a nuclear plant near a border, such as Barsebäck, which is often discussed in this literature. The nuclear plant Barsebäck was located in the south coast of Sweden, very close to the Danish border. So although Danes would be tremendously affected if a nuclear disaster were to occur, in fact, much more affected than Swedes living up north, they do not have a say. They do not have a say over the decision making of Barsebäck, which seems undemocratic. On the defendant account, it's justified from a democratic standpoint that Danes living sufficiently close have their interests taken into consideration through access to deliberative fora that feed into the decision process and where deliberation is reflected in the outcome. Yet Danes should still not have voting rights in the coercive decisions about Swedish nuclear energy politics, its aim, overall goal, and shape of its basic institutions, as long as they are not systematically and over time subjected to it. So this is the kind of basic thought behind that. Okay, so now to sources of normativity, something that I've been writing a lot about in the last years that I don't go into too much here, but I think it's useful in this particular way. Because the main question I get is always, why not the all affected interest principle all the way? So to explain that, I think we must analyze criteria of inclusion, not only in relation to basic values and in relation to functions, which I've done so far, but also in relation to sources of normativity and the distinctively political normativity involved in theorizing democracy. So distinctively political normativity, as I understand it, includes the political norms and values that regulate and structure the political domain. Paradigmatic example, the value of political liberty in contrast to freedom, for example. Compare this with moral norms and values treated in moral philosophy proper, at least from Kant and onwards. Paradigmatic examples being equal respect for autonomous agency, that individuals are free and equal. So by this, I don't mean that political normativity is independent of moral normativity, as argued by many political realists. I think quite the reverse, which is evident from comparisons with the paradigmatic subdomains of morality, such as parental ethics, ethics of law, medical ethics. In these areas, particular norms and values are specified and argued for. Typically, it's argued that certain roles within this domain, such as being a parent, a judge, or a medical professional, include special duties and obligations that constrain what one ought to do as parent or as judge or as medical professional. So consequently, it may be true that Andrea has done what she ought to have done as judge, for example, convicted a citizen in accordance with the judicial law, although the law was morally unjust. Now, of course, it's controversial, if at all, and to what extent moral considerations may trump what the judge should do as judge. Maybe there are cases where the judge or parent, what they should do as persons, as moral agents, override what they should do as bearers of particular roles. But even so, rather than indicating that parental ethics or medical ethics are not moral domains, it indicates, in my view, that they're moral domains with a given parameters, which makes them brief or limited. Since in order to assess what parental and medical virtues and norms are, we have to take into consideration the particular circumstances of parenthood and the medical profession. Conditioning the norms and virtues on these circumstances, they give us an opportunity to argue for more specific norms and virtues. So similarly, I think we can view the political domain and the particular circumstances that play a significant role in assessing the normative status of different instances of politics. For example, what we ought to do as citizens may differ from what we ought to do as persons. So this is, and more specifically in this context, I argue that the solution to the boundary problem should take the norms and values regulating and structuring democracy and the particular role of the member or potential member into consideration. For instance, even if procedural fairness is essential for democracy, it cannot constitute a normative ideal of democracy standing by itself, because then we will simply replace democracy with theory of fairness. Democracy is an ideal about a particular way of organizing a community politically, where members often indirectly govern themselves through fair procedures. So I argue that democracy expresses the value of political autonomy, which is concerned with political authorship, where members shape the political community through authorization. This, I argue, cannot be achieved by letting affected persons have a say over separate decisions or a predetermined set of issues. Because the exercise of political autonomy, as it is understood here, requires also, among other things, control of the agenda, as expressed by Robert Dahl, which is generally considered to be a fundamental property of democracy. The control of the agenda includes the right to determine the overarching societal goals and aims, including the distribution of power between public institutions, as well as the basic form of these institutions. And I think these properties cannot be captured by an all-affected interest principle. So that are three ways in which I try to argue that they're compatible. It's basic function, basic values, and sources of normativity. So let me conclude by briefly mentioning what I see as the two main objections to this account, one focusing on autonomy and another on political influence, or what I've called authorization. So the first objection, and as noted by several theorists, connecting coercion with autonomy is problematic. Because even if coercion has deep impact on the autonomy of persons, for example, on their ability to lead their lives in pursuit of their conceptions of the good, some non-coercive interventions might have that too, as argued by Lara Valentini has argued, for instance. So the decision to build a nuclear plant near a border discussed earlier is a case in point. Therefore, to fully honor the equal respect for personal autonomy, many theorists instead have favored the all-affected interest principle. Godin, Valentini, Gustav Arrhenius, and others. I think this criticism has primarily been directed at accounts that rely on a very narrow notion of coercion, understood as physical coercion. But the function-sensitive account proposed here works with a much broader notion of coercion. I didn't discuss that here, but it also includes, apart from physical coercion, also what I have called authoritative commands, and thus involves also a socio-psychological aspect of coercion. So this would capture much more of these cases where they have objections. But even with the broad understanding that I defend, there might be non-coercive decisions that have an impact on personal autonomy. So that's true. The reason why I don't find this problematic is that political autonomy is not seen as personal autonomy, in my view, but only as an important aspect of personal autonomy. So we can lack political autonomy, but be fairly autonomous as persons. For instance, if we were wealthy and very influential persons in an autocracy. At the same time, full personal autonomy requires political autonomy, since only through political autonomy may persons become members and rule over themselves by shaping the overall goals of the political community in which they live and its basic institutions. However, in contrast to personal autonomy, political autonomy is not abolished as soon as one does not have influence in one single decision or a predetermined set of issues. Taking part in shaping the basic institutions and overarching societal goals, for example, whether we want a welfare policy or something like that, is a long-term process, and it's upheld by continuous involvement in the decision procedures among those that are systematically and over time subjected to coercive decision. So that, I think, is an important view of political autonomy. It is necessary for full personal autonomy, even if it can't be equated with personal autonomy. So the second objection concerns influence, or what I've called authorization. A common worry is that, for example, electoral vote hardly could count as influence, since, other than randomly or rarely when our vote happened to count, such as it tips the scale to our, as it were, as Kolodny and others have argued. But from a democratic point of view, this is the wrong way of understanding authorization through which political autonomy is exercised. It is not primarily a causal notion or an epistemic notion, but a normative one. Authorization in the political sense intended in my paper has two core properties. First, it is understood as mediated authorship. Of course, we are rarely the sole authors of anything we do in life. So it's a mediated authorship through institutions, representation, and social norms. Secondly, it does not concern individual decisions, but the overall goals and societal aims, as well as the shape of our basic institutions. So that is how I meet this second objection. So 23 minutes, I think I'll stop there. Thank you so much. Okay. So now I've removed that, yes?
No, not at all. Thank you very much. So we now have still half an hour, 40 minutes or so for discussion, which is great. There's some people online, and I have to make sure that I keep track of them. So if you want to ask Eva a question, please write in the chat, I have a question, and then I will ask you to post that question. So that's for those who participate online. Oliver Feltham has a question, and for those who are here in the room, just raise your physical hand, as usual, and I will ask you to ask a question. Okay, so Oliver Feltham, Professor Feltham is first.
So thanks very much for your talk. I'm not that familiar with the literature or the terminology, but I was just wondering, when you talked about people who are affected by coercive policies, at what point within the methodology or the framing of the question are animals no longer considered? Because there are a whole series of decisions that are made within industries and within governments which subject entire populations, entire species to very coercive situations. I know it doesn't fit within what's called the boundary problem, but I'm just wondering, where exactly is it in the actual framing of the boundary problem that question is excluded?
It's an extremely good question. It's also very embarrassing when people raise the question about animals, because this whole debate has been very, since it's about participating in the demos, and animals would presumably work better with P2, that we try to represent their interests. So my view that I try to develop here could be also, I think, be inclusive of future generations and animals and so on, but P1 cannot, because then you're supposed to be a political subject, exercising your political agency in a ways that animals can't. So it could be the case that I could do that, but I'm also a bit embarrassed that I'm not interested in animals. I mean, I love animals, and I have a dog, which I treat very well. But it's just that it's so complex as it is. So I guess, you try to move from the more fundamentals, and then, yeah.
Okay.
I think it's a very good question.
Thank you.
Thank you. Peter Stone has a question again, if someone else, and then Peter Stone and then Carlo Burelli. Peter?
Hello. I'm very interested in this distinction you're drawing in terms of these two principles, but the part where I'm having trouble following is how that distinction gets connected to the law policy distinction here. Because if I understood the argument here, the democratic principle, it's not specifically about the authorization of any law in particular. It's about, if I understood, it's like it's at a stage, it's at several stages before an actual law is created, as you put it, in terms of like goals, aims, or whatever that are steering the law. And if it's at that level, sort of height, I'm not quite sure why that's more closely connected to law than it is to policy. So I'm wondering if you could maybe say a bit more about why, why viewed that way in terms of that's what the democratic principle should be connected to, why that more naturally feeds into law than into policy.
Thank you. I guess, first of all, when you start digging in this, in the beginning, there were many bets on the all affected interest principle, because focus was very much on somehow the agenda was already implicit or set. So it was most of the versions of the all affected interest were typecasted against individual decisions. And since I'm interested in, I'm more interested in democracy as an ideal of self-rule, it's not the core fundamental normative point is not whether you're having a vote in a certain decision, but what society you want to form and what kind of basic institutions. So that's how I came into this distinction, but it's the coercive element. So for instance, in the global setting, it might be that some laws are not supposed to be regulated by P1 at all, even if they're called laws, because they're more like policies. So when I've done work on global political legitimacy, this becomes much more messy, because many of what we call laws are not real laws in the hard sense, and some policies in the future might be coercive. We don't know. It depends on how global governance. So I think it's the coercive elements that is the important one. It's just that typically in a domestic context, that's when we are forced to do this or that, which we are not with policies. So we need to comply, whereas with policies, I guess it's enough with kind of non-interference or not destroying any. So there are different kinds of obligations at the uptake side of every principle. But I guess also this goes to that I somehow have in mind, but I'm not clear on that here, but it must be, so it's not individual laws, it's more the legal system as a whole that is connected to a certain society. It's problematic. My colleague Ludwig Beckman has a similar approach, but with you're subjected to the legal system, that ends up in a lot of other problems, I think. So it's different bullets to bite depending on what is the subjected entity, so to speak.
Thank you.
Thank you. Carlo Burelli is next.
Yes. Should I speak from here? Can you hear me?
Hi.
Hi, Eva.
Hi, how are you?
Very, very interesting paper. I have, so I really love the distinction in the decision-making function that you make between policies and laws. I think that's very important, and that is often lost in the debate. But I had a question about a different thing, actually, which is political normativity.
Surprising.
Yeah. No, I follow the analogy with role morality, and it's interesting because there you accept some kind of possible tension between the proper moral judgment that a judge or a parent may do as a person, as you write in the paper, and then the different normativity that comes from their role as parent or judge. But then I was wondering how this sort of tension between moral and role normativity translates into your account of the boundary problem. So it wasn't immediately obvious to me that one of the principles should be more properly moral and the other one more properly political. And I was wondering whether there could be the same tension that the judges faces or the parent faces in the political arena with respect to the demos.
Thank you so much. I don't see one part of it as moral, and I see both the principles that I develop is I mean, it's the first one is drawing on. I'm not saying that the second one is from moral, some other domain, because I have a very different. I mean, I don't see that as I see that as the whole domain is practical normativity. So I don't see the basic as moral normativity, but practical normativity. And that depends, and then we have certain subdomains depending on what context we're in, for instance, medical professionals. So it's rarely the case in political philosophy that we do moral theory, period. Often we're already in a kind of, this is a political problem with the boundaries. So I don't see that as two different, so it's more like layers of normativity. But what I'm working on a paper now, which I would love to hear your thoughts about, that actually tried to develop this role normativity, what it would mean for political theory, which I don't do enough in this paper. So, because one immediate role that comes to mind is the citizen, of course, because it is through the role as citizen we get all other roles, like if we want to be representatives, if we want to be involved in politics and so on. But on the other hand, that's like not very helpful for the boundary problem, because the whole question is, who is the citizen? So that's like, you can't really put the cart before the horse. You have to figure some other role out. And then I've been working with the idea of the aspiring member. So it could be the migrant or the expat or somebody who wants to become a member, but it's not legally so yet. I think one has to be looking at some role on that level for it to have some, so to be useful in this boundary context. So, and then the whole question, of course, becomes when do other kinds of normativity trump the role as political member or aspiring member or citizen? And that, I think, it depends. I mean, we can find examples when it's very important to do certain things as persons, even though you wouldn't do the same in the role as citizen. I don't know if that was any clarifying for you here, but
yes, thanks. But also the question then becomes, and it's very interesting, but maybe it's best left for another for the other paper, but where the normativity from the role comes from, right? Because the assassin is also a role, as you well know, but we don't think that their role normativity should at all matter with respect to a wider normativity about what we should do as a person, right?
Yeah, I mean, again, I don't see it as, they're all part of practical normativity. So we might as well skip the whole talk of sources of normativity and just say what we ought to do as parents or as persons or as medical. We can also not use this terminology, but I think it has some pedagogical merits, because a lot of the literature on the boundary problem has been coming from a more moral philosophical perspective, which sometimes distorts what democracy is about. So, but for me, they're all part of practical normativity, and in this case, they're all I would call it the subdomains of morality sometimes, and the subdomain of practical normativity, asking question what we ought to do, how we ought to organize society. So, since I don't see that as many realists do, like a dichotomy, it's either political or, so I don't see that as a problem. It's more like layers, or different way of expressing more specific norms in relation to roles. That does not mean that they're non-moral or that there can't be something else. So it's more, I see it more like that.
Okay, great, thank you. Gideon has a question.
Hi, Eva. Thank you very much for speaking with us. It's been very fascinating. I've noticed that Miller also comments about that significantly affected interests having a due consideration. But he sort of leans towards an all-subjective principle interpretation of the boundary problem, but with that significant caveat. And that seems similar to me as your P1 and P2 thing. That P1 should be the predominating thing when it comes to coercion, and P2 allows for due consideration. Would you consider this piece to be disagreeing with Miller, or do you find it more of a deep dive onto the same theory?
Okay, so I from the seminar room, I don't hear so well. Did you, the first part, was that David Miller's part?
Yeah, David Miller says that he tends to believe in the all-subjective principle.
Yeah.
He says that, but it has a caveat that there should be due consideration given to significant interests or a significant piece affected. And I'm wondering if you think that your work here is that seems to parallel what you have with your P1 and P2.
Yeah.
If you think your work disagrees with Miller, or if it's a deep dive into the same ideas.
Yeah, I think our intuitions about democracy is the same, or I share a lot of that, even also with Rainer Baubeck. But they insist on Baubeck, for instance, argues similarly that we have to take for territorial boundaries for as a given when we theorize boundary problem, and I think that's a methodological mistake, or it's not a mistake, but they're not clear about the implications, because that's another question, what we empirically have and what we're starting from. But I try to distinguish that from my original kind of more abstract first order question. So for me, I would say that Rainer Baubeck's or David Miller's proposals are perfect proposals in a non-ideal setting. So if we want to theorize non-ideal principles, we have to start with what the boundaries are and try to revise the boundaries in a democratic way. But that's not my project. So the only constraint I have is a very broad feasibility constraint. But I think my suspicion is always that they build in a lot of feasibility constraints in their arguments, but it's not exactly defended and it's not explicitly articulated. That's my hunch. But I think they would be compatible as more ideal and non-ideal parts.
Okay, thank you.
Okay, Mallory?
Yeah, I had a question. I'm not sure how relevant it is, but it's more of an epistemological question about the, because I'm also kind of new to this, oh, am I right there? Hi. To this all affected interests terminology of the boundary problem. And so is there any sort of consensus on an approach for presenting evidence that one is or is not considered an affected person? By that I mean like who's the implications being that they would or would not have a say in the decision making of certain policies and certain, not necessarily the overarching goals that the DEMOS agrees upon through, like you said, things like mediation, social norms, basic institutions. But let's say that in your nuclear power plant example, what would the process look like if there is really a process at all of someone in Denmark bringing forth the case that they are an affected an affected individual who has interest?
Yeah, I mean, in practice, this is of course a mess, but it's not meant to be applied directly on any practices. Right. So more like a critical yardstick for assessing more non-ideal proposals. So that's the aim. It's more like a broad strokes, trying to put down the foot in certain dimensions. But did I hear you correctly that you framed it as an epistemological question, right? Who defines interest? And I got pressed on this on a conference actually by Simone Chambers, who was also talking on the DEMOS21, I think, earlier, into this fundamental interests view. And there I say that in a note now because it's really too big a question to try to deal with in one paper. But I think that some fundamental interests are defined as interests that are generally intersubjectively recognized as fundamental for humans to survive and be safe. So I think a more elaborate view on those fundamental interests must be answered by a more comprehensive theory of justice. And what would be fitting from my intuition would be something similar to Rainer Forst's theory, right of justification. So I would never go into this kind of circular trap and try to argue that the best way of defining fundamental interests is to vote on it for something like that. I think that will lead us in the wrong direction. So it's more of what would generally and intersubjectively recognize as fundamental. And I don't think that is too hard, actually. People always react to that, and then they have, for instance, I don't know if you've read in this ideal, non-ideal theory debate, but a criticism of Rawls is that it's very hard to imagine in a global setting that people would be attracted to the second principle of the difference principle. And the argument has been, for instance, from Colin Fairley and others, that it's better to have kind of a deliberative approach. So we deliberate about what justice is and so on. And for me, that strikes me as so much more ideal to think that we can have a global deliberative democracy than just having a minimal idea of justice that we institute. So I'm not sure which one is more realistic, actually. So I think that sometimes fundamental interests are not that controversial when it comes to really, really basic needs. Yeah.
Thank you.
I would have the next question, unless there's anyone else. And for those who participate online, again, please write in the chat if you happen to have another question. So thanks again for this very interesting talk and discussion. I have a question about the role or importance of political equality. And as you may know, in Miller's recent contribution to the democratic boundary problem, he argues that the democratic boundary should be set relative to the values of political equality and solidarity, because these would be two central values necessary for the realization and perhaps also constitutive of democracy. And if I understood it correctly, you are arguing that the political normativity of democracy is political autonomy, that you are recognized as an author of the decisions to which you are subject to. And ad hoc, it seems that both considerations are important. Political equality is important. Political authorization is important. Fairness is also important, but I'm wondering what happened to political equality in this paper, so to speak, where democracy now ends up just being this political autonomy view. And as you know, Cristiano and many others have defended the importance of political equality. So I was wondering what you think of the place of political equality in democracy and in this argumentation that you present in this paper, in this talk in particular.
Yeah, thank you so much. I mean, I've written a lot on political equality, and especially in a global context where nobody ever talks about political equality anymore when they talk about democracy. So democracy has become more like accountability and things like that, political legitimacy. So I've written a book, edited a book on political equality in transnational democracy, and this is very close to my heart. It's just that it's been going on for a long time. Why I have replaced in this paper with political autonomy is because there's something deeper going on with political autonomy that I think captures something more fundamental. Because political equality, that's why Cristiano has to build in an equal stakes condition, right? So it's only sufficiently fair if we have equal stakes. So then political equality is the baseline. So one of the attractive features with the all affected interest principles, I think one of the attractive features is precisely that it is gradually coded, so that you are more affected. If you're fundamentally affected, you should have more interest represented than if you're just tiny affected. Otherwise, it would be very strange. On the other hand, laws are not gradually coded. Either you break the law or not. So either you're subjected to a law or not. So what I find attractive with the all subjected principle is that it harmonizes much more with how law works and how coercive decision making works. But still, the hard thing with political equality is that, I mean, if we take Sweden, we have regions, and I don't vote in the north. I vote in the Stockholm region, and we have locals, same as you have in Paris and in France. So I guess in a more abstract way, we're already have equal stakes in every domain. So I think we have to have this kind of equal stakes for political equality to be a sound idea. And then I agree that it's core, but that's not itself what makes democracy attractive. I just find it plausible that we should have an equal say, but that's under the presumption that we live in a common world in terms of Christiana's terminology and also have equal stakes. If it weren't the case, if suddenly I could vote on what they should do in northern Sweden, we would not find political equality attractive. So I think that's why I've been trying to get to this political autonomy instead to capture the deeper commitments about self-rule. Mm-hmm. But it's not easy for me to not talk about political equality. But I think, yeah.
Thank you very much. Steve has I may have a quick follow-up. So what is the status of this argumentation that you're presenting when we identify democracy with one or the other value, and you've been arguing that the justificatory question is prior to the empirical question, that there's a justificatory priority over the empirical priority. But if we argue in this way and say that democracy is closely related to political authority than it is to political equality, unless we have a certain limited understanding of what political equality is, then it seems that you draw on empirical considerations, or you draw on intuitions as to what democracy is, and I'm not quite sure what the method is that we are applying if we are pursuing these types of arguments.
Okay, so of course there are empirical facts behind one's idea of democracy, because we only have our history of democracy and the ideals from which we. So the only thing with the justificatory priorities, I think that what has annoyed me in this debate is that when you try to argue for the all affected interest principle, you're doing very much like philosophy proper, without a deeper notion of what democracy is apart from a decision method, like the more deeper connection to political autonomy and self-authority. But on the other hand, the all subjective principle has been building on a lot of empirical conditions that are not, the status of which is not clear. So it's not that we can't have empirical conditions as part of a theory, it's just that it has to be clear what it is. And I think that the justificatory priority that I see made by Miller and others is that because we need a territory to even start talking about decision making, because decision making apparatus is already implied, and in order to have that, we have to have a political community and so on. I think that the problem is that the justificatory priority does not follow, because their conclusion is that then we must start with not the constitutive question, but the domain question in Miller's view. But I think this similar mistake that political realists make with Bernard Williams' idea of the first question is the question of stability and security, because that might be empirically true, that we can't have justice principles applied to war. So it might be the case that stability and social order is a prerequisite for all other normative ideals that we want. But that empirical priority does not entail that the normative priority of principles regulating the first question. It could still be that we need that justice is the first. So that's totally different. So that's what I mean by the priority view. It doesn't follow that must come first normatively. Yeah.
Okay. Thank you very much. Steve is next.
Thank you. This is just a fantastic paper and a very interesting talk, and I'm extremely sympathetic to, and I think this idea of the functions and sort of separating those out. I think that's just a really useful tool to try to bring this this opposition together. I guess I have a whole series of questions, but I'll just ask the one, which is what struck me about this paper, and maybe this is the most simple question, so maybe you'll just answer this right away, but I guess as I was reading your paper, the one thing that struck me immediately was the way you want to map coercive and non-coercive onto law and policy. And in some ways, and I understand within the argumentation, that's very convincing. Okay, so this. I'm pushing you a little bit, perhaps outside of where you'd like to go, but it actually strikes me that in many cases it's quite the opposite. That is, that that legislation, for which we actually have the most elaborate form of procedural fairness, that is through hundreds of years of constitutionalism and modes of voting and very elaborate schemes for how we do legislative power, it strikes me as generally perceived in democratic theory, or at least in terms of the history of democracy, as the least coercive mode of collective decision making. Whereas policy, and if we extended that to statutes, ordinances, everything that's, for example, gone on with the COVID-19 pandemic that has forced us to stay home, wear these crazy masks, right? That is very coercive. And that's actually where we're the most troubled, is that we don't feel like we're actually participating in administrative, regulatory, statute policy. And that in many ways, that is the most coercive part of our experience. So this doesn't necessarily challenge the broader framework, but it just struck me, my immediate reaction was that particular mapping of coercive and non-coercive onto law versus policy struck me as in many ways not intuitive, especially, let's say, in the context of emergency rule or much of what is pushing our democracies to the brink right now, presidential orders, regulatory decisions. Take the European Union. Nobody has a problem with, or the problems that are being decided in Strasbourg are not the ones that most people are upset about, right? So it's the ones that are being made in Brussels and et cetera. So that's sort of the most basic question, and I don't know if you have a response to that, and I'm not sure that it upsets your general framework, but I just wanted to ask that question.
Yeah, I actually didn't want to talk about law and policy at all, but because as we talked about earlier, it might differ. Some policies are more coercive and some laws could be totally non-coercive. But it's just was a way to get it more practically, to get it more appealing to like real life politics as we know it. So I'm fairly open to that, that can change. So the coerciveness, but I think that most of the cases that you told me now would be covered by my second notion of coercion, second aspect, not the physical one, but the authoritative command, that you follow the societal norms that tells you. I think, I don't know, because what pressed me on this kind of non-physical coercion that I'm more socio-psychological, I call it, is when I got the question on a seminar that what about the decisions to allow, as I said in the paper, the pedestrian to cross the street when it's red light. You're not coerced when some law is removed in the physical sense, laws are removed, but you are in the more socio-psychological sense. So I think that in some examples with wearing masks and so on, I don't know how it is in France, but in Sweden, we have had no coercive measures during the pandemic at all, just recommendations.
Yes, I mean, in France, it's been very coercive. And I guess the question is just, the broader question is, I guess that this opens onto is, can, in the way you have presented it, when you write both principles are essential because they accommodate two different values that are indispensable when theorizing how to regulate these functions, procedural fairness and political autonomy, while decision-making generally raises a problem of fairness or procedural fairness, which is all affected, coercive decision-making raises a question for political autonomy. But I guess the question is, does the distinction between procedural fairness and political autonomy map onto questions of political autonomy when it comes to questions of regulation, administration, and statute and ordinance, which are in many cases the most coercive elements of when we are confronting public authority? Can you effectively put those solely on the side of political autonomy, or should administration not also be subject to questions of procedural fairness? I guess that's the question I'm raising. That is that once you set up the problem as coercion versus non-coercion, and you basically, I mean, maybe you don't stick to this, but in the paper, you have law and policy making on the one hand, and then lawmaking on the other, then it looks like what you're saying is that policy, statute, ordinance, regulation, administration is not a political autonomy problem. That's what it looks like you're saying. So maybe I misunderstood.
But on the other hand, the examples you gave now, they would be covered by, I mean, P2 is not only to policy making, it's to all decision making. So I guess procedure fairness will go anyway. Because it's not policy, non-coercion, and law coercion. All decision making, the P2 gets triggered.
Okay. It's not exactly how you present it in the paper, but
okay.
I mean, you might in one portion of the paper you're quite clear on this distinction, and you clearly set it up as one being on the one on the other. I think you're right. I think that both trigger both principles, but then we have a question of the function. Because if you don't have a functional distinction between the type of coercion or non-coercion that's taking place, then how do you distinguish when you would invoke all affected or all subjective? Do you see what I'm saying?
Yeah. I mean, the P2 is easy because it's on all decision making, but the tricky one is P1. Yeah, I understand what you're saying. Yeah.
So it just seems to me that you're setting it up as a distinction, and I'm not sure that you can actually parse out fairness, procedural fairness, and political autonomy for one portion for one function, and not for the other. They seem to me they both apply to both. And at that point,
no. I mean, my argument, it's fully open that there are other values. Procedure fairness is also involved in the P1, right? It's just that I'm talking about the core value. It doesn't exclude that it's also procedure fairness. It's just that I don't say that it's the only value. I think I'm trying to say what is the core value. But so it's actually neutral vis-a-vis that you would say that, well, P1 actually expresses fairness as well, because it does. Political to have an equal say in the decision making is a kind of fairness as well. The tricky one is that I don't really have the value of political autonomy when it comes to P2, though. There, I don't see how that could. I don't see how the all affected interest principle can promote political autonomy, whereas I can see the opposite, as you say, that it's also kind of procedure fairness. What's going on when we exercise political autonomy in a democratic way?
Yeah, exactly.
I'm not super happy with the term procedure fairness overall now, but
I guess, and so, well, you just said it very well. I mean, it's part of then it also raises the question of exactly which functions you're talking about, because at some points in the paper, function is presented as corresponding to a certain type of decision making, law versus policy. And in other places, you sort of, it's that function it sort of applies to both.
Yeah.
And if it applies to both, then I'm not quite sure on what grounds you're invoking one principle towards one function, another principle towards another function. It seems to me you're basically posing both for all cases.
Yeah, thanks. I have to think about that.
Yeah, but it is a fascinating. I love the idea of trying to differentiate and work through this. So thank you for the paper.
It's always, you know how it is when you, every distinction, it's a war.
Yes.
You have to put down the foot and then you regret, why did I do exactly that? Yeah.
Exactly. Absolutely.
All right, I just read in the chat, and I could have read this earlier perhaps, but there's a question by Torben Knobloch. Do you see the chat yourself, Eva?
About?
Yeah, he's interested in your thoughts on immigration policy and border control. You bring that up in the last part of your paper, but if you could like provide a summary of your view, of what your present view is on these issues of immigration policy and border control. Not all of it. So to the excuse of Torben, I haven't sent around the paper because I only sent you the note earlier today, and that would have been too late for you to read the paper. So no need to excuse there. My fault rather, but if you're already interested, what does this imply for this topic?
Yeah, I mean, now what I do in the paper is that I try to connect to the discussion or dispute between Miller and Arash Abizadeh, because that has been gone viral a bit in this discussion. And I think that, I mean, according to one quite dominating view in the current interstate system, empirically, a democratic polity has the right to unilaterally control its borders. And this is what they discuss. So only the members of the polity are owed justification when decisions are made of whether foreigners should be allowed in or not. So this is, Abizadeh rejects this view and tries to say that democratic policy must be justified both to members and non-members. And I don't know if you're acquainted with this discussion, but since the demos of a democracy is in principle unbounded according to his view. So just to read out from the paper, his argument is that the core value of both liberalism and democracy is personal autonomy. So state coercion always violates personal autonomy because it subjects an agent to the will of another. Enforcing a regime border control is therefore an act of coercion. So that's why he said that to be democratically legitimate, you can't just say that members have a vote on the border control. So Miller disagrees because he's arguing that excluding would-be immigrants is not necessarily a coercive act because it depends on whether that immigrant has other options instead. But from my view, it doesn't, I mean, Miller tries to draw on this negative positive distinction, whether you're just forced or non-forced or just not let in. Just because you can't get exactly your ice cream flavor, there are 3 other flavors. That would not be coercion. It's only that you don't have any other food and you need that. So that would be, and I think that's, I think that negative positive distinction between act and non-act, I don't think that at all catches the normative essence of what's going on with coercive decision making. So I think Arash is right in that. But I try to argue that since for me, it's also not just, I think that democratic right to participation in this coercive act of subjection, I see them a little differently than Arash because I have this function sensitive view. So what I'm interested in how they take place. So my main difference from Arash is for me, it's someone has a right to be included. It depends on the frequential or the frequency and the temporal dimension, because my P1 already says that builds in a kind of proviso that it has to be systematically and over time. So in a sense, I go with Arash's conclusion, but restricted. So it's like in between Miller and Arash in that as soon as somebody knocks on the door, you don't need to include them in the decision making. For me, it's more a robust demand that they have to be systematically over time subjected to the rules in Sweden, for instance, to get in as migrants. So I guess it's a more demanding idea, but it's not drawing any normative ammunition on that, on the negative positive act distinction as Miller tries to make, that you're just preventing someone from coming in instead of coercing someone. That's his main. So I think Arash is right that that's not where our intuitions, that's not what's going on. For me, it's much more the frequency. If somebody happens to be there and is not included, P1 is not triggered, but only P2 if you're affected. But as soon as you're systematically there and over time, P1 is triggered, and then you should be included. So that would be kind of my position in this practical issue vis-a-vis Arash and Miller.
Thank you. Torben, would you like to ask a follow-up question? Or no? Okay, you're good. Great. Then Carlo has a second question, and Gideon as well. And if anyone else has a question, let me know. Also, those participating online, write it in the chat. Okay, Carlo and then Gideon.
Sorry, I just have to head to another meeting.
Sure.
But I just wanted to say thank you guys again for setting this up, and thank you, Eva, for presenting.
Okay. Yeah. So Carlo,
yes,
is next.
Thank you, this Mallory. Question comes a little bit from the discussion that you just had with Steve, and I was thinking about what exactly are the functions that are involved in the background, right? Because there is a broad decision-making function, and then there are different. So are we really talking about two different functions when we are thinking about legislative and executive decisions, or are there two sort of different mechanisms of the very same sort of political function that would be take decisions that are binding for all the people involved? Because traditionally, there was a huge distinction, and just thinking about Rousseau, for example, very different treatment of executive power and legislative power. And today, I think in political theory, we mostly talk about laws rather than policy. But that, I think, it's an important side of your paper to make a distinction there between these different kinds of decision making institutions within contemporary democracy. But I was just wondering whether we're talking about two distinct functions, or whether they are rather two different mechanisms through which this broad function of binding decision making, or of creating a sort of field of decisions that are not to be challenged by the people, as opposed to, I don't know, friend decision of going in that or the other restaurant, right? Laws cannot be challenged, but also executive decisions cannot be challenged. I cannot just take away my mask here right now. So I think it's an important distinction to draw, but I'm just not sure how we can draw it in a sort of solid way. And I was wondering whether you can share your thoughts on this.
Yes, thank you. So, well, I would like to see it as two different decision functions, but we can move up one level of abstraction and say that there are two aspects of decision making. That I don't think will make so much difference. But why I don't want to go down to the mechanism level is that because I think that's when I say law as the kind of mechanism through which we realize or to get the coercive decision making expressed through law. So I would rather see the policy and law as the typical mechanisms. Does that make sense? Rather than one level up saying that it's coercive or coercive and non-coercive, that's the mechanism. I think they are more fundamentally different, because whether you're subjected or whether you're actually affected makes a normative difference. So I think it's better to see the mechanisms on the level of the expression of how they are instituted in the lawmaking and the policymaking. But again, I'm not very strongly committed to any of these terms, actually. So I just try to make clear the difference between coercive and non-coercive decision making, actually.
Yeah, I understand, but just very briefly, yeah, I think I agree with you that laws and policies are better as a candidate for mechanisms, but still, to think about function, I think we would need something more, like to say that they correspond to two different systemic needs of a polity. And I was wondering if this, maybe it's just too theoretical to try to get our heads around, but I was wondering whether this is true or there are just two broadly distinct ways in which we maintain political order.
Yeah.
I think it, just to jump in here, I mean, I do think we have a historical, political, philosophical precedent for this, which is, generally speaking, the distinction between constitutionalism, law, legal framework, talking about, and what would generally fall under the category of administration, right? So these are the two forms of, in France, it's in political thought, it's oftentimes referred to as a distinction between right and social obligation, right? And which doesn't necessarily, as you pointed out, map onto citizenship, because citizenship usually belongs, and I think your instincts are absolutely right there, citizenship usually belongs to the domain of the legal, that is, the rights and duties that are prescribed through constitutionalism, but you're also talking about membership and social obligation. So I do think we have two functions there. For me, and I mean, I think you seem to be walking back from this, but on page 11, your argument does seem to hinge on the fact that law is coercive and policymaking is not. So I think what Carlo is saying is that the paper may be pitching the function at the wrong at a higher at a level of decision making that it may need to go down one more level of decision making to something between sort of law legislation, which we manage through representation of constitutionalism and rule of law, et cetera, and then this sort of administrative regulatory ideal, but that those two functions cannot then map onto coercive versus non-coercive. They're both coercive. And they both have a relationship to procedural fairness and to political autonomy. They're both involved in both.
Yeah,
So
but now you're talking about constitutional, more fundamental law and regulatory. That could also be lawmaking, right?
It is lawmaking. I mean, it depends on whether you're in a
So in this paper, I don't make a difference between constitutional and ordinary law in P1. They're all coercive because we're subjected to them.
It's just that policy policies, I mean, it depends on how much you want to fit under policy, but policy is a very expansive notion that makes reference to a whole set of other functions. And so,
and this, I think, is a strength with policy in this context, actually. That it's I mean, in all kind of the whole administrative apparatus, with all the kind of subdomains of enforcing and implementing laws. And then there's so I agree that's an expansive notion, but I think that's since P2 is much less demanding, I think that's quite good that to use a commonsensical view of policy to, as I describe here, using a very accommodating view of policy. but one struggle that I've had with this paper is that I didn't know this about contemporary political theory, the journal it's forthcoming in, that they have a much more broader, they want to have a broader readership. So the reviewers were bashing on my paper for being too abstract. So in the beginning, now, so this with the law and policy, I moved on a much more abstract level with very little connection to equivalent functions in the real world. So, so trying to catch the intuitions that I had about this. So I guess it's also been a struggle to, as soon as you try to find examples of what you're looking at, there are always counter examples when you go down and try to make empirical examples. So that has also been a problem in the paper. As soon as you try to find something mapping on to your idea of coercion and idea of non-coercion.
All right, we have one more question by Gideon, and I think then we will close the session.
I think mine's a short one. We recently read the Miller paper, and so Miller in that paper brings up the issue that even if you include exceptional minorities, maybe who are affected, they may be ignored even if they have voting power, but especially with just consideration, because they don't have the power to sway a decision overall. And especially if they're considered only on decision by decision basis, they don't necessarily have the lasting power of participation in institution to make up for that. And he says not only might they be ignored, but the new voices may even cause current political powers to dig in against any objection. And I'm just wondering if the affected parties who are covered only by Principle 2 only have the power of being considered without much teeth to that power, what mechanisms do they have to protect themselves from those phenomena?
I mean, that's a very good question. I mean, one problem with P2 is that standing on it by itself, it's not much to do with democracy at all, right? So that's one thing I think I'm clear about, that it's only with the P1, in combination with P1, we get a robust idea of people having, leading their lives in a democracy, in ruling of themselves. So that's P2 is deliberately more weaker, but also more broader in applicability and scope. So these, on the one hand. On the other hand, I think if one looks at my definition of the kind of conditions for P2, I said this, having that taken into consideration through voice, but having access to deliberative fora that feed into the decision process. And this is quite demanding, and is reflected in the outcome, this Habermasian idea. If you think about that, that would actually mean quite a lot. So it's not only that they're represented ideas and nobody cares about whether in the outcome they're all reflected. So it is not nothing, it's quite robust, but of course it's a problem, because if for this question that you raised, that it doesn't take us all the way to kind of self-rule in a democratic sense. But I think if you look at it on a glance, it looks very, very non-democratic and weak. But if we really were to implement it, it's quite a big difference from I mean, it's quite demanding, even if it can't compare it to P1, of course. But if you have interest represented in a public way, this is the Cristiano publicity condition that I think is very important, that for him, and I agree, it's not only that we have a democratic rule, but it's also that we want to see justice be done. So it's all public. So that's the publicity condition in P2, I think, is also important, so that they get publicly recognized as having certain interests that need representation and need to fit in. But I agree, it doesn't take you all the way to, yeah.
Thank you.
Great. Okay. I think we will end the session here. Thank you very much once again, Eva, for taking the time to discuss this paper with us tonight. It fit in very well into the DEMOS21 series, and we also have many people here at AUP studying these subjects, so there was a great opportunity for us to have this discussion with you today. The next DEMOS21 talk will be in 3 or 4 weeks, November 10th, with Jamila Muscat. So stay tuned. Thanks to the participants, and see you all.
Thank you.
One day.
I want to thank everybody. Thanks for great questions, and thank you so much.
Okay.
Super great questions. A warning flag for those of you who work on the boundary problem. It's like a black hole. But it's fun down there in the darkness. Yeah.
Okay.
Thank you.
Thank you. Bye-bye.
Bye.